This is a lecture for my professional responsibility class, and we're going to be talking about Model Rule 1.8F. Model Rule 1.8F, this is one of our conflicts of interest rules, and this is one of the specific rules under 1.8 that refers to the lawyer's own personal conflicts of interest with the client as opposed to conflicts between clients. I have to warn you, this is about a third-party payer or the person paying for the lawyer's services, and we already covered this to some extent in the comments to Model Rule 1.7. I mentioned at the time, not only is it in the comments to 1.7, it's also a standalone rule. Some jurisdictions may not have adopted this 1.8F as a rule in their jurisdiction, but if you violate this rule, you are also probably violating 1.7 according to the comments to that rule, and everybody has 1.7. So let's proceed, and I have a little diagram here showing you the most common scenario where you have the provider and the consumer and the insurer showing you who's paying who. So here we go with F. A lawyer shall not accept compensation for the representation of a client from one other than the client unless, we have three unlesses. One, the client gives informed consent. Two, there's no interference with the lawyer's independence of professional judgment or with the client-lawyer relationship. And three, information relating to the representation of a client is protected as required by 1.6. So the client has to consent and they have to know who is paying. So no stalker exes calling the lawyer and say, hey, I want to be an anonymous donor and cover this person's legal fees so that I can weasel my way back into their life and have them owe me something or something like that. So the client has to know who's paying and has to agree to it. And the person paying can't interfere with the lawyer's professional judgments or with the client's decision in the representation, and nor can they demand information that the client doesn't want you to share about the representation. And all of this is a very common problem. This is fair game for being tested on the MPRE, but what you're going to see when I describe this is a scenario that is going to be very relevant when you're in practice. Okay. Comment 11 to Rule 1.8 addresses 1.8F, starts the discussion, and it continues into comment 12. So comment 11 says, lawyers are frequently asked to represent a client under circumstances in which a third person will compensate the lawyer in whole or in part. The third person might be a relative or friend, an indemnitor, such as a liability insurance company, or a co-client, such as a corporation along with one or more of its employees. So these are the three by far most common scenarios. That I mentioned the sort of anonymous donor, secret admirer, the ex that you have a restraining order against who wants to pay your legal bills as a way to kind of edge back into your life. But these are the everyday situations, right? So who are we talking about? Very commonly, parents of grown children. In other words, when you go to college, when you have a kid who goes to college or is in grad school, they're over 18, they're an adult. So they can make their own legally binding decisions. But a lot of 18-year-olds, to be honest, and even people in their early 20s, when they get into legal problems, they can't afford their own lawyer, and their parents, they're so financially dependent, and their parents hire the lawyer for them. And then we have a problem that the parents start wanting to tell the lawyer what to do, and the parents are not necessarily the client. The person the lawyer's representing is. In that case, they're an adult. This would be different if you have a minor child where the parents get to make the legal decisions for the child anyways. Very, very, very common that insurance companies hire lawyers at firms outside of the insurance company to represent their policyholders, either because the policyholder is being sued or the insurance company is paying the policyholders medical bills because they're under disability insurance, and they are going to seek compensation from the person, from whoever injured their policyholder. And most insurance policies essentially you assign your rights to sue to your insurer on the condition of accepting payment of the bills. And then very common that corporations are co-defendants with their employees, and the plaintiffs will sue both. And I want you to think about for a moment why. Why does a plaintiff's lawyer sue both the person who committed the harm and their employer? Well, the employer is the deep pocket, right? And so a lot of times the tortfeasor, the individual is judgment proof, right? If you have millions of dollars in injuries, and you're injured by somebody who's a truck driver or something like that for a company, or even a mid-level management, and maybe they don't have that. Maybe the top-level management is judgment proof, and so so you put the company because they're the deep pocket and you're more likely to get compensated. On the other hand, why don't you only sue the company? Well, it's always easier to prove that the person who actually committed the harm, that they're guilty and they should have to pay. And so it's always more of a reach to bring in vicarious liability. So so lawyers like to list both and hope and see what sticks, so to speak. And because the employee and the employer, if they're sued together, their interests in the litigation are generally aligned, they will often share a lawyer. Because third-party payers frequently have interests that differ from those of the client, including interests in minimizing the amount spent on the representation and learning how the representation is progressing, lawyers are prohibited from accepting representations unless a lawyer determines that there will be no interference with the lawyer's independent professional judgment and there is informed consent from the client. And so this is a persistent problem that the insurance company hires someone to represent their policyholder, and insurance companies don't want this to cost any more. So they're likely to say, we want to settle before trial. We don't want to hire experts. We don't want to hire jury consultants and things like that. We're told if we're paying the bills, we want to do this as cheap as possible and get this over with as quickly as possible with as little expenditure as possible. And sometimes the policyholder really wants to press the claim for all it's worth. And it's a very different type of calculation, and it puts the lawyer in a difficult position. Sometimes it will be sufficient for the lawyer to just obtain the client's informed consent regarding the fact of the payment and the identity of the third-party payer. And so think about this, that you have the third-party payer, and you can just get consent about this. But if the fee arrangement creates a conflict of interest for the lawyer, then you have to follow 1.7. The lawyer must also conform to the requirements of 1.6 concerning confidentiality. And if you're watching these videos in order, you haven't gotten to the confidentiality rules yet. But basically, you have to have the client's authorization to share any information about the representation with anyone else. And let's say you have an insurance company that's paying the lawyer's fees. They want the lawyer to submit bills and explain what they did during that time. Were they just sitting around shooting the breeze with the client, or were they doing research and running to court and making appearances and filing things and so forth? And that doesn't sound like deep, dark secrets, but it is part of the confidential information. So now in practice, you're just going to get the client to consent to communicate, to give the insurance company updates. When you have a test question on the MPRE, really hone in and look for, did the client consent to the lawyer giving information to the insurer or the third-party billing company or something like that. Under Rule 1.7a, a conflict of interest exists if there's a significant risk that the lawyer's representation of the client will be materially limited by the lawyer's own interests in the fee arrangement or by the lawyer's responsibility to the third-party payer. For example, when the third-party payer is a client. And by the way, I see payor spelled, the ABA is now using ER. And if you see older work, the archaic spelling that sometimes you might see in my slides, it has OR. Okay. Under 1.7b, the lawyer may accept or continue the representation with the informed consent of each affected client unless the conflict is non-consentable. And this has to be in writing. Now, if it's an insurance company, they do this just customarily. Part of it's going to be in the policy, and then of course, they're going to consent to accepting the lawyer and accepting the arrangement that the insurance company is paying for it, and so forth. But let's go to the situation where it's the union hiring a lawyer for one of the members of the union at a union shop, at a factory, or parents of grown children. They have to consent. The child has to consent to the fact that the lawyer is accepting payment, and there could be a conflict. The most common situation, as we said, is insurance defense work, parents hiring counsel for their grown children, and employers paying the employee's legal expenses, and sometimes friends and relatives pay for each other's legal fees. Um, and Now, what about someone coming in hiring a lawyer to draft a will for their parents? So you have a middle-aged adult, they have elderly parents, and so they are trying to get their affairs in order because they're worried the elder is going to pass soon, in their final days, and so can they draft the will at the request of the existing client? If the client is a potential beneficiary? And the answer is yes. The testator has to give informed consent, and the ABA explained this in 2002. Get informed consent from the testator. The testator, in theory, is a client, but it's pretty common that some of the heirs might be covering the lawyer's bill to draft the will and do the estate planning and so forth. By the way, when it comes to insurance companies, keep in mind that, and I'm going to go off the slide for just a moment here. The ABA has said in ethics opinions that it's possible that the insurance company is a co-client, and they're not answering that question. They haven't really given us an answer, and so there is no right answer for test questions. There's no question if you're hired by an insurance company to represent a policyholder that the policyholder is a client. And what we don't know is if you're going to have to look at the case law or ethics opinion in your state, if the insurance company who's paying the fees is just a non-client payer of the fees, or if they are a co-client, which, as we spent a lot of time talking about, under 1.7. Let's see what else we still have to cover here. Let's talk about some criminal cases and what happens here. And the trial courts are supposed to ask some questions about this. And so this type of conflict can also come up in criminal cases. And what are we talking about? I'll give you the Hollywood scenario. The mafia godfather hires the lawyer when one of his henchmen or hitmen gets caught, and so forth. The family's lawyer represents the person. If you have any other type of a drug cartel or street gang, this is an episode, the running theme in the Better Call Saul television series, where there's a drug cartel at some point that starts using Saul Goodman, the character Saul Goodman's legal services, and hiring him to represent their kind of street dealers and other people that get into legal trouble. And so if the judge can tell, and same goes with pimps and prostitutes and things like that, so you have someone who has the financial resources to pay for other criminal defendants who may not even be a co-defendant. And it's one thing if they're a co-defendant, but sometimes they're not. But if the court realizes it, the court should ask a lot of questions on the record before trial and consider the option of disqualifying the lawyer. If it becomes clear that the lawyer's judgment, loyalty is really to the person paying the bills, which, as you can imagine, may be the case if it's the cartel or something like that. So the courts should inquire. The other example that has come up is with police brutality. These police brutality cases where there's lawsuits against the police officers, and a lot of times the police union, this has been, and I don't have to explain this as much now to my students because police unions have been a topic of intense media coverage in recent weeks and months prior to making this video after the tragic death at the hands of the police of George Floyd. And so police unions are a real force, and they do provide lawyer up the officers in their department or in their union when they get sued, and provide the lawyer. And as you can probably guess, these police unions can take on a life of their own and are thinking about the interests of the union sometimes more than just the interests of that individual officer, right? So they definitely want to preserve the union and preserve the force and preserve the rights of other police. And this can, again, create conflicts of interest um, for the lawyer. Also, sometimes the police union, as we're starting to see with the litigation that's going on right now, over recent brutality cases, and especially the excessive uses of force in response to the protests after George Floyd's death. Sometimes the police union is listed as a co-defendant, and they are paying the lawyer, but they are co-defendant in some cases. Watch out for conflicts of interest in that situation. Here's our attendance quiz question. If you need to document that you watch this because you're one of my students, a college student is facing criminal misdemeanor charges, and his parents hire a lawyer to provide representation. The parents instruct the lawyer that under no circumstances should the lawyer agree to a plea bargain that involves any jail time. They don't want their precious little one spending even one night in a jail cell. Should the lawyer follow the instructions of the parents as they are paying the fees? Yes or no? Hopefully you know the answer to that from watching this video. If you don't, you might want to review.